Hello, hello, hello. Thank you so much for watching. There will be no shameless plugs for kettlebells or kettlebell Dan in this video. I apologize that the kettlebells appeared. What we are going to do is we're going to make fun of Fred Fudbert, Fred Fudstone, Fred Lambert, and we're going to talk about a $329 million, or is it a $240 million? Is it a $243 million? We're going to talk about big verdict against Tesla in Florida. And for those who don't know me already, I am a retired Florida lawyer. This was in a Florida court. This was in federal court, in a federal court that I've been in. Not in the specific judges, I don't think, but I've been in federal court. And so I think this will be helpful if you want to understand what's really going on with this lawsuit. But let's start with our friend, Fred Fudd.
Ended up suing McGee and Tesla over wrongful death and the damages that come from the crash. Ended up suing.
So Fred is sort of right. They did sue the driver McGee, and they did sue Tesla. He didn't sue him in the same lawsuit as Tesla, and that's the reason this case is in federal court. If they had sued them both together, there's something called federal diversity jurisdiction. And I'm just bringing this up because Fred did a 10+ minute video explaining the case, and he got so much wrong, and that's typical, and that will help you guys understand what's really happening in this case. And I just think it's funny to bring Fred in for this because I think he's even Canadian. He might be from Quebec or something. What are you doing talking about American law? He's not a lawyer, but we'll have more of Fred later. So let's start with what happened. What happened was there was a verdict, and the media did what the media usually does. Ooh, Tesla, bad news. We can make a big story out of it. And you can see CNBC, Tesla must pay portion of $329 million in damages. Okay, sort of correct. Tesla hit with $243 million in damages. See, what CNBC got right was portion of something. Tesla hit with $243 million in damages. NPR, $240 million. CNN, Tesla ordered by Florida jury to pay $329 million. Wait a minute. CNBC says a portion of $329 million. CNN says that a jury ordered to pay and must pay. Okay, no, not must pay. Elon Musk, you got to slip Elon's name in there. Elon Musk's Tesla ordered to pay $243 million over crash. Okay, so a critical distinction. I don't think I have this anywhere else in my slides. I have a bunch of slides to help inform you. Right, slides to inform. There's no order. A jury does not order. A jury issues a verdict. It's a finding. This is what we think of the facts. This is what we think the number should be. The jury doesn't get to decide this is what the number will be. The judge decides that. And an appeals court decides that. The jury does not issue an order. The judge makes a decision. The judge does make orders during a case, and the judge issues a judgment. Just like legal technicalities, but but it's not just a technicality. Juries do not order anything. Okay? Juries make decisions, and the judge then will have what's called post-trial motions. There will be some decisions made. Most likely the judge, before it ever gets to an appeal, the judge will make some changes to this. And the numbers will come down. And the judge might throw some things out that he let in to the trial. We're going to find that out. So one of the critical parts of this case is a $200 million punitive damages award. And in my opinion, it's an opinion. I am a lawyer. I have dealt with punitive damages cases a little in my career. Most lawyers have very little experience with, how are we doing, by the way? Most lawyers have very little experience with punitive damage cases, and that's because punitive damages cases are rare. So why are punitive damages cases rare? There's reasons for it, and let's go into what the United States Supreme Court says about punitive damages. In Exxon, so one of the issues here is, well, what is this about, $200 million, right? So I had a brief conversation with Grok about this. I'm not guaranteeing that Grok is perfect on the law, but I think Grok is generally correct. So one of the things is, how much can the jury award in punitive damages in a case? Can they just find the person broke a fingernail and then say, well, we don't like Tesla, so $1 billion in punitive damages? No, there's limits. So in Exxon Shipping versus Baker 2008, the court reduced punitive damages to a 1-to-1 ratio with compensatory damages, citing the need for predictability and fairness when compensatory awards are already large. The compensatory awards here are very large, right? So the punitive damage cases, if the compensatory damages, sorry, just to be clear about that, compensatory award that compensates the person who was injured or the family of the person who died for what was lost. So, and for the pain and suffering that they endured. You're compensating them for, maybe they had lost income, maybe they had medical bills, and you're compensating them for the suffering that they experienced. And it's common in a wrongful death case, in the right circumstances, which I don't know how that turned out in this case. It's common to award substantial compensation in a wrongful death case. The idea is the person was badly hurt. Maybe they knew they were going to die, whatever. There's a question about conscious pain and suffering. That's getting too deep, and I don't see that topic in the case that I've seen so far. So what sustains the idea of giving this much money and on the compensatory side? And then so you have the compensatory, which is to compensate you for what you lost or what damage you suffered. And then the punitive is to punish the bad guy. In this case, they're saying Tesla's the bad guy to make him do better in the future, to teach him a lesson, to teach other people a lesson, right? That's the point of punitive damages. So the court has noted that higher ratios may be permissible, but only in cases of extreme reprehensibility, in which what you did was really, 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 really bad, right? Drunk driving 150 miles an hour through a school zone when the kids are out, maybe that's extreme reprehensibility, right? With low compensatory damages, but even then ratios significantly above 4-to-1 are scrutinized. Now, I think the number here that applies to Tesla is around $40 million. So 160 million would be about 4x that. 200 million would be over that number. And what I'm submitting is that the punitive damage award probably can't go over 1-to-1. Fred Fudstone in his, I think I left this clip out from Fred, he said that it was a 3-to-1 cap. And his source, of course, was Electrek, which is a highly reliable source. So, how are we doing? How are we doing here? Just checking to see who's here. Okay. So, exact limit depends on the case specifics, defendant's conduct, size, compensatory damages, but the trend in some rulings reads towards tighter ratios, often 4-to-1 or lower. That's Grok. And I'm sure that there's, when you get lawyers talking, anything can happen. But I think that Grok is generally directionally correct there. Then the other question is, when do you get punitive damages at all? Right? What did you have to do? What's that extreme reprehensibility? It must be sufficiently egregious or reprehensible. I think BMW versus Gore was like the dealer, I think it was BMW repainted a car after it was damaged and then sold it without telling the buyer that it was repainted. And then the damages award was like, it was like $9,000 in value in the car, and they awarded, I don't know, $100 million in punitive damages. I'm making up the number. And the Supreme Court said, no, can't do it. So you need evidence. The degree of reprehensibility is the most important factor in determining whether punitive damages are justified. So here's a question. How bad is it what Tesla supposedly did in this case, which we'll talk about later, and does it reach the level of punitive damages? And I think that's a tough one. I don't, and the judge fluffed it. We're going to talk about that shortly. There must be clear nexus between the defendant's wrongful conduct and the harm suffered by the plaintiff. It can't be awarded for conduct unrelated. So in other words, if Tesla's doing a lot of this is actually going to be relevant here. Tesla, Elon Musk says, oh, it's perfectly safe. It can drive across the country without anybody looking. But if the accident would have happened anyway, well, then there's no nexus. Which is one of the issues is, are we sure this accident wouldn't have happened anyway? This is something that was never addressed in the court decision that I read. I don't know what happened at trial. We don't have that information yet, but the decision that I read is what happens before trial. Well before trial. It was in June, sets the stage for the trial. There's another document about motions in limine, but that's not as helpful as the document I read, which is the summary judgment motion decision. Fair notice. The defendant must have had fair notice that their conduct could result in punitive damages. That's probably okay. Non-arbitrary application. Due process requires that punitive damages not be opposed arbitrarily. The courts must ensure that the awards are based on evidence of wrongdoing and proportional to harm caused, avoiding speculative or purely emotional bases for awards. it's tricky. But my point here is what you're going to see is the conduct that Tesla is accused of in this case does not meet the reprehensibility standard. What they did isn't that bad. And the Florida Supreme Court has made it clear that in automotive products liability cases, the standard is whether the car manufacturer exhibited a reckless disregard for human life, equivalent to manslaughter. Equivalent to manslaughter. That's one step short of murder by designing and marketing the vehicle. Equivalent to manslaughter. Think about that. Think about that. How bad does it have to be manslaughter? Okay. And what the judge said, because Tesla refused to geofence the autopilot system despite being warned of the dangers, it's loose, and despite record evidence indicating that Tesla was capable of curing the issue, other companies have limited their driver assistance systems, they're not really self-driving systems, so that they won't work on the type of road that the car was on. It wasn't on a highway. A reasonable jury could find that Tesla acted in a reckless disregard for human life for the sake of developing their product and maximizing profit. Maximizing profit? They're not making that much money on it. This is back in 2019. This is a 2019 Model S. I'm not even sure Tesla was making a profit. And I don't think Tesla was making a profit in 2000, not making much profit in 2019. And I didn't see, again, this is, what happened in front of, like, I didn't see any evidence in what I read so far to show any evidence that Tesla was making profits. And that was even considered in the case, as a fact in the case. So the judge just pulled it out his butt. I don't see what happened here as manslaughter. We'll go through the facts. So let's dive into the facts. Let me check in the chat first. Chadwick says an absolutely ridiculous outcome. It clearly states on the website that driver is responsible. It is much worse than that. What this driver did is way worse than what you think happened. Okay. How does Tesla terms for use put onus on driver? Terms are specific. Mafia voice. How are you doing? I do not know of an automaker whose emergency braking system is not overridden by the See, somebody's on it. Somebody's read something by the accelerator being used. Ferrari should be in jail. Yeah, look, Ferrari makes cars that go 200 miles an hour. Why aren't they in jail? You could see where that could be a problem. In Florida, punitive damages are limited to 3x the compensation awarded. It's not that simple, John. First of all, this is in federal court. They do apply Florida law. And yeah, 3x, the maximum, the award was $43 million compensatory that applies to Tesla. 3x would be 129. And the jury awarded $200 million. So you have a cap there too. I'm not certain about whether the 3x punitive damages limit applies in this case. Probably does. But that's the top. That doesn't mean there aren't other limits that bring it down lower. Sounds like a case of suicide with the owner's responsibility. No, the dead person, the people who were injured were pedestrians who were on the side of the road. We're going to get to that in a second. Tesla's a big hash, honeypot, so there will be many more lawsuits. I don't believe there will be many more lawsuits. Fred's going to say that, and I'm going to address why he's wrong, and no offense, David, you're wrong. So the case is Benavides versus Tesla. McGee is the guy driving the Tesla Model S, had activated vehicles autopilot, including the traffic-aware cruise control, which, among other things, restricts the vehicle's speed to 45 miles per hour when the vehicle is not operating on a highway or a limited access roadway. If you know the Keys, this is in Key Largo, Florida, there's like one main road that goes from Miami to Key West through Key Largo. And then everything else is more like a side road. I'm sure there's sections where there's something more major, but most roads are minor roads. So should autopilot have worked on this particular road is a question, but it restricted his speed to 45 miles per hour on that road. However, McGee subsequently manually engaged the vehicle's accelerator, increasing the vehicle's speed to 62 miles per hour and temporarily disengaging the TACC speed restrictions. He set the car on autopilot with a 45 mile an hour speed, and then he pressed down on the gas pedal, the accelerator pedal, and held it down. He didn't manually engage it. He pushed his foot down on the pedal and held it there. It gets better. Or worse. As he continued driving toward the Card Sound Road intersection, he dropped his cell phone and immediately reached down to pick the phone off the floorboard. Didn't take his foot off the accelerator pedal, of course. While he was reaching for his phone, the vehicle detected a stop sign, a stop bar, the road's edge, a pedestrian, and a parked Chevy Tahoe. But the vehicle did not provide McGee with any audio alert or other warning of the obstacles and never engaged its emergency brakes because he's got his foot on the accelerator pedal. He put his foot on the pedal. That disengages all that other stuff. That's the point. He's just got auto steer on. The car's steering straight because he told it to steer straight. He pushed on the pedal. All this stuff that didn't work because he pushed the pedal down. Because McGee also failed to observe the traffic signs and obstacles, he drove through the intersection, failing to brake before striking the side of a Chevy Tahoe and then drove into two pedestrians. One woman was killed fairly quickly, I think, and her, quote, boyfriend, we're going to come to that later. Her, quote, boyfriend was badly injured. And then how well did he recover? There's some questions about how much his injuries were caused by the accident. And so towards the end of this live stream, you're going to hear that. So, we get some more Fred now.
April 2019, a man named George McGee was driving his Tesla in Key Largo in Florida, and he was using autopilot and his phone at the same time, something obviously you should not be doing. And he dropped his phone and tried to reach it, lean down to reach it. And when he did that, he was arriving at an intersection. April 2000.
So Fred says when he drops the phone and then picks it up, he was arriving at an intersection. When he drops the phone, he's arriving at an intersection. Close. Not close, Fred. McGee acknowledged that the road signs were visible if he had looked up, and that had he been watching the road, he would have had a clear and unobstructed view of the T intersection for a long distance, at least 1,000 feet. That's 300 meters for those who like metric. At least 1,000 feet. Now, 60 miles an hour, remember 62 miles an hour. 60 miles an hour is 88 feet per second, so 62 miles an hour is about 90 feet per second. It's 11 seconds. Minimum. He's not looking for a minimum of 11 seconds while keeping his foot on the accelerator pedal, keeping the car going 15, 17 miles an hour. That's like 90 kph, by the way. It's like maybe even close to 100 kilometers per hour. He's not looking for over 11 seconds. I don't know how the judge, I don't know if the Tesla team, the Tesla legal team pushed this point. At least 1,000 feet without looking. That's more than 3 football fields. According to McGee, there was nothing that prevented him from acting to prevent the crash. But it's Tesla's fault, right? Shortly, this is how much worse it gets. Shortly after the crash, he calls 911, tells the operator, "Oh my God, I wasn't looking. I don't know what happened. I ended up missing the turn. I was looking down, and I dropped my phone. Oh my God." Officers arrived. He told the officers, "I was driving. I dropped my phone and looked down. I ran the stop sign and hit the guy's car. It was actually because I was driving. I looked down. I've been using cruise control." He was using autopilot. I think we know that. "I've been using cruise control, and I looked down. I didn't realize, and then I sat up. The minute I sat up, I hit the brakes and saw his truck." In the heat of the moment, this is like one of the most critical things. In the heat of the moment, as it happened, he said, "I'd been using cruise control." He didn't say I was using autopilot. They're going to say, well, he thought he had this magic autopilot so he could do whatever he wanted. Well, on the scene, he said he was using cruise control, which tells you he has a different view of how capable this software is. But that doesn't really come up much in the decision. I think that should have been picked up more. Also told the officers he was driving on cruise, going for it, and he looked down to get the phone he dropped. Then he reached down. Then he popped up and looked. He saw a black truck. It just happened so fast. Yeah, 11 seconds. 11 or more seconds. It happened so fast. It happened so fast, folks. This is we hear this all the time in an accident. It happened so fast. I'm not giving you it happened so fast if it was over 1,000 feet and you were going 90 feet per second. It's a minimum of 11 seconds. Probably 12. Somewhere they mentioned 5 seconds in this decision, and I'm like, no, it's 11. Who did the math here? By the way, This is not a physical toy that I'm playing with on this. I've had multiple people say, "Where did you get your Optimus?" It's just a transparent image. I'm not actually moving it with my hands. I'm moving it with my mouse. Just a fun fact. Okay, let's move on. We got more Fred Fludstone for you. And do not look at the kettlebells.
But what's interesting with this case is that the fact that the driver did take the responsibility, but added at the same time that he thought that the autopilot system would help him. So let me pull out the quote here exactly. So McGee said after the crash that my concept was that it would assist.
He didn't say this immediately after the crash. This is later. Let's be clear. Fred's not being clear. When did he say? I haven't seen this. I didn't see this in the court decision. I saw something like it in the court decision, but I didn't see this quote in the court decision.
The quote here exactly. So McGee said after the crash that my concept was that it would assist me should I have a failure or should I miss something, should I make a mistake, that the car would be able to help me. And in that case, I do feel like it failed.
Yeah, and it would have if you didn't have your foot on the pedal. He had his foot on the pedal. He overrid the safety features. Fred, he had his foot on the pedal. Wait, it gets better. I can't believe it gets better, but it gets better. Following the collision, he said that he understood that autopilot did not make the car self-driving, and that it was his responsibility of the driver of the vehicle, even with autopilot activated, to drive safely and be in control of the vehicle at all times. Also acknowledged that he understood before the crash that it was his job, not the vehicle's job, to detect and react to a stop sign or a red flashing light, and it was his responsibility to be aware of the surroundings, the speed limit, and other traffic control devices on the road. Yeah, and by the way, I'm pretty sure the speed limit on this road, I didn't see it anywhere in the decision. I'm pretty sure the speed limit on this road was way less than 62 miles an hour. We got more Fred. But let me... I believe that he... well, it'll come up. I'm sorry, I may have my slides out of order a little bit, but there's more Fred now.
Argument is quite sound because based on what the driver himself is saying, he's saying that if he wasn't so confident in the autopilot system, maybe the crash would not have happened. So
he dropped his phone. He wasn't looking. He reached down. What does this have to do with confidence? What does this have to do with confidence in autopilot? And he has his foot on the accelerator pedal. Just because he has confidence, no one said, hey, the car will do everything you want as long, and you can keep your foot on the accelerator pedal. Are you kidding me? And this is key because a lot of people say, well, Elon said autopilot's amazing. You know, Tesla had made some claims. They had this video that said that the car can drive without supervision. There's no evidence that McGee saw the commercial or that he heard or read any statements Elon Musk had made about the 2019 Tesla Model S. He testified his beliefs about the capabilities came from looking at information on the vehicle. That's it. Page 23 to 24 of whatever document that's from. An expert, one of the experts for the other side, for the people suing Tesla, conceded that autosteer did not cause the accident. One of their experts. And McGee overrode the system in the more than 30 seconds before the crash when he pressed the accelerator pedal to achieve a speed of 62 miles per hour. He had his foot on the accelerator pedal for more than 30 seconds before the crash. He's not on autopilot. He's on auto steer. And the expert for the other side said that the auto steer did not cause the accident. Tesla claims that under these circumstances, a message would appear on the vehicle's display after 6 seconds, informing the driver that the vehicle would no longer automatically brake, which of course he wouldn't see because he's not looking. He's not looking. I wonder whose fault this accident is. I'm trying to... Somehow this is Elon's fault. Everything is Elon's fault. You know, I hurt my back yesterday moving into this... was it today? Yesterday we moved into the house. I hurt my back. Slightly. It wasn't too bad, but it's Elon's fault. And I want punitive damages from Tesla. While McGee conceded that he was responsible for operating the vehicle safely and failed to do so, that does not necessarily lead to the conclusion that he alone is responsible for the resulting collision, particularly giving McGee's testimony that he expected autopilot to avoid the collision. Look, for those who follow me, and I think posted this on both X and on YouTube, I backed my car into the wall of the house. 3 days ago. Tesla has all kinds of safety stuff. I know whose fault it was. I didn't call Elon up and say, Elon, it's going to cost, like $50 to fix this wall. Would you, kick me some money? It's like, no, it's my fault. Well, and people are like, well, Warren, didn't the automatic emergency braking kick in? No, that's not what AEB is for. Well, Warren, didn't the car beep? It beeped. I'm an idiot. The car beeped. The problem with the car beep, and the problem with all this stuff they're saying is the car beeps so much, you don't listen to it anymore. You get too many warnings, you don't listen to them. It's Boy Who Cried Wolf. Oh, there's another bit in here. I don't think I included it in this. They're like, well, Tesla needed better warnings. He didn't read the warnings he got. He testified he didn't read the warnings. And then it's like, well, you needed better warnings. You needed more warnings. How many warnings you want? He didn't read them. If you had one warning that was like one paragraph, maybe he'd read it. But if you throw 10 warnings at him, oh, you needed 20. No, you needed one. So this is where we get into like a substantive issue, which is you wonder, well, wait a minute. If this guy's such a retard, he drove like such an idiot, how the hell is this Tesla's fault? So there's this concept called proximate cause. We're getting into some lawyer talk. I know you guys love the lawyer talk. Proximate cause. If a butterfly flaps its wings in Kansas and there's a hurricane in China, there's a theory under chaos theory and meteorology that the butterfly flapping its wings, believe it or not, it's called sensitivity to original conditions in chaos theory. There's a theory that butterfly flapping its wings caused the hurricane in China. But it's not proximate cause. Okay? If I'm driving down the road and the kids are talking in the back, and that's a little distracting, but I'm going 150 miles an hour and I'm not looking at the road, not because of the kids, because my girlfriend is, I'm looking at the girls in the bikini on the side of the road instead of looking where I'm going. Yeah, the kids in the back talking might have interfered with it, but they're not the proximate cause. Now, there's an argument, and the judge makes it here. The law is clear that there may be multiple proximate causes of a given injury as long as each is a substantial cause of the injury. So the real problem here, and the judge is going to go the other way, obviously, and then the jury went the other way, is what did Tesla do that's a substantial cause of this injury? We got more. One of our other favorite Tesla haters and Elon haters is next. Plaintiff's expert Dr. Mary, aka Missy Cummings. Although McGee did not testify as such, McGee thought this car was going to pick up his slack, and he felt like he dropped his phone. McGee's the driver, right? Okay, so McGee didn't say this. Thank you, JC. Oh, that's very kind of you, JC. He says, I know you're moving and busy with that right now, but really appreciate you taking the time to provide us with this. The only time I'm happy to hear lawyer talk. So, yeah, just quickly, we moved. And we're in, and we slept here last night. We got a pile of junk on the floor. Got all my stuff on the floor. I got to put it away. And then, like, the water stopped working, and we had to figure out what's going on with that. My wife really took care of that. I didn't do anything. And we're living life. But I did take some time today to actually. We were out with the kids, and she's doing stuff with our nieces, and I'm looking at my phone, reading all the stuff, and getting ready for later. Literally, these slides probably came from me laying in the back of the Model Y. Reading my phone while we're out with the kids and her friends. So McGee thought the car was going to pick up the slack, and he felt like he dropped his phone. What's the big deal? My car's got it. See, McGee didn't say that. Right? He never said it. But of course, Missy Cummings of Duke University and a Biden appointee to the National Highway Transportation Safety Administration, the woman who wanted to punch Elon Musk, she says, well, he didn't say it, but he thought it. This is one of their experts. I'm serious. And this is how great of an expert Missy Cummings is. That the guy didn't say that's what he was thinking, But she knows that's what he was thinking because she's an expert. Because what? Notwithstanding her conclusion that the collision was a result of McGee's confusion about autopilot, Cummings acknowledged she had no scientific study or empirical data to support the opinion that Tesla's auto-steer beta message or Tesla's use of the term autopilot was confusing to users. This is one of my friends just said this today. Oh, well, the term autopilot, that's confusing to users. I'm not. Who's an idiot? The guy himself wasn't confused. He knew. We can go back to the facts. He knew what his responsibilities were. Right? He understood to not make the car self-driving. It was his responsibility to drive. He understood. It was his responsibility to drive safely and be in control of the vehicle at all times. He said it was his job. But, Missy Cummings says, well, he didn't really understand. Right? He didn't say it, but he didn't understand. I don't know. So we get to the judge. Even though plaintiff's expert could not definitively conclude there was a defect in autopilot's utilization of the auto emergency braking and forward collision warning systems, the factual dispute is significant enough that the court should not dismiss the claim. In other words, Tesla's saying, hey, they can't prove it. In my experience as a lawyer, what the expert says is, it's my opinion to a reasonable degree of, this is literally the language that lawyers use in court, that experts use in court. The lawyer asks this question: do you have an opinion to a reasonable degree of certainty, to a reasonable degree of professional certainty based on your profession, as to whether this defect, whether there was a defect in the system? Okay, and the expert testifies, it's my opinion to a reasonable degree of professional certainty that there was a defect in the autopilot's utilization of auto emergency braking and forward collision warning systems. And he couldn't say that. The expert could not say that, could not definitively conclude. And the judge says, well, there's still a factual dispute that's significant. No. As a lawyer, I'm just like, what the hell are you talking about? If the expert says I can't say that, then there's no significant physical. It's their job to prove it's true. If you bring in an expert and the expert says, well, I can't definitively conclude that, then you haven't met your lawyer language and you haven't met your burden. You bring an expert in to say this is what happened, and the expert says, well, I can't really say that. Out. You're out. You're out. Absurd. Okay? But the court is saying, nope, that's not enough. We're not going to grant summary judgment. We're not going to dismiss those claims. This gets tossed on appeal. I'm not an expert on anything. I'm retired. This gets tossed on appeal. That, you got to be kidding me. The court finds that plaintiffs have provided evidence affording a reasonable basis to conclude that more likely than not, a defect in the autopilot system, remember the defect that the experts couldn't conclude was a defect. A defect in the autopilot system was a substantial factor in bringing about plaintiff's injuries. The fact that the guy wasn't looking for 11 seconds while stepping on the accelerator when he shouldn't be stepping on the accelerator, that's not so overwhelming that Elon said autopilot's great once, and the guy didn't listen to Elon and didn't pay attention to Elon and knew his responsibilities, still a substantial factor in bringing about the plaintiff's injuries. As this court discussed in its Dalbert analysis, Dalbert is expert whether experts are allowed or not. Plaintiff offers sound, competent, and reliable expert testimony from Moore and Cummings that autopilot has several design defects. No, they couldn't include that. That they opined were a substantial cause of the subject collision. You saw what the experts. The expert said other things. I can't do this video and show you everything every expert said. Right, it's in the decision. But you saw some major holes in the expert testimony, and the court just said, close enough. We got to give the jury a shot at this and see if we can ring the bell. According to the court, rejects Tesla's request for summary judgment based on the absence of expert causation testimony. In other words, the experts didn't have enough to say there really were defects, and they didn't have enough. Because here's the problem with the causation. What if the guy had been driving another car and he dropped his phone? And he's going Let's say he's got cruise control, but he sets the cruise control at 62, or he puts his foot on the accelerator pedal, on the gas, whatever, to go faster than what the cruise control wants. And he drops the phone. Like, who's to say he's not going to go get the phone and not look for 11 seconds? How do you know that this guy would have driven differently without autopilot? We don't know that. Where's the proof that because you can't know that? All right, so let's see where we are. We're going to get to Fred in a minute. Let's see what we have in the chat, though. Has Warren had any babies yet? I have 2 adult children, and I'm fairly confident we will have a child by the end of next year. Not Elon time. Not Elon time. These Tesla haters want to be responsibility of debt for dead people if we would lose FSD. Yeah, well, that's another thing, Mark, that when you get to the punitive damages issue, which I don't think I have any more slides on that. I don't see any accounting for it. In fact, I couldn't put everything in all the slides that I could have possibly done in the video. I don't see a balancing of like, well, does this make the cars safer? Is there an objective determination one way or another? Are Tesla cars with autopilot safer than cars without? Because there's clearly it's clear that Tesla submitted expert testimony that their cars are safer with autopilot, because it's actually mentioned. I think Missy Cummings is critical of the safety report, but it's clear that Tesla showed, hey, our cars are safer than other cars. Our cars have fewer crashes when they're on autopilot. When they're not on autopilot, they have fewer crashes than other cars. It's not clear that information was in front of the jury, and that was in front of the jury, that was presented to the judge, or that the judge ruled on it. I don't see it. I know there was some evidence of that in front of the judge. I don't know how much. I don't know if that's a mistake of Tesla's lawyers. I don't know if the judge refused to consider it. That's not clear from the decision of the judge. I probably could have read more documents, but there's a limit to what I can get to, and I'm not. Some of the stuff I can't get. I shouldn't say I can't get to. That it's. You have to have a Pacer account, which I used to have. I have no idea if it's still active, and I'm in Thailand. Is it going to work when I'm out of the country? Do I have to go through a VPN? There's all kinds of things that go on there. How much did the judge get paid? Federal judges make something like $200,000 a year. I don't necessarily think the judge was paid, and I wouldn't jump to the conclusion that the judge is against Tesla yet. Sometimes this is a theory. Shouldn't say it's a theory. I have reasons for believing this to be true. Sometimes a judge rules against the party it thinks is going to win, to give the party it thinks is going to lose less to appeal. But if the party actually wins, if the party he thinks is going to lose actually wins, after the verdict, the judge can say, okay, I'm going to take a look at those things I said before, and based on the evidence that was submitted at trial, and I'm looking at all these things again, now I have to reconsider my decisions. I'm going to say this again. Strategically, if you're a judge, judges don't like being reversed on appeal. So a strategy for a judge is, I think Tesla's going to win this case. For whatever reason, the judge might have thought that. I'm not saying this is true. I'm just saying this is a theory about how judges think. I think Tesla's going to win this case in front of the jury. I'm looking at everything I see here. I think Tesla's going to win this case. So I'm going to rule against Tesla more than I might on things that I think might be close calls. So that when Tesla wins and the other side wants to appeal, they have less to put forward in an appeal. And I'm less likely to lose, to be the judge who is reversed on appeal. Definitely a thought process some judges might have. I have some experience with judges. I don't want to get into that. So it's possible that the judge did this for other reasons and will fix it, because first you have the verdict, then the judge has to consider post-trial motions and make decisions. What is he going to do with? Is he going to throw some of the stuff out? Is he going to throw out punitive damages? Is he going to reduce punitive damages? Is he going to reduce compensatory damages? A lot of things the judge can do after. We don't know what he's going to do yet. Okay. So this doesn't mean he's an activist Tesla hating judge yet. And he did make some rulings, and there's something called motions in limine. He made several rulings in favor of Tesla along the way. So it's really hard to judge that one. Mark says stepping on the accelerator is worse than the 10 seconds. It's 30 seconds. He's got his foot on the accelerator for 30 seconds. Defect in the human driver is more accurate. How is this even a case and not tossed out from the beginning? Yeah. I think I just addressed that. Michael says Missy C applies her logic in one direction only. The driver expected the car to do this for him, but Tesla can't expect to pay attention to the road. IAW the terms. I think Missy Cummings, and I addressed her earlier, like very clear that she didn't make any sense, and the judge let her go anyway. Justices don't work well in highly polarized societies. I think I want to defend the justice system for a second. I think our courts work pretty well. You get some outlier cases like this. Think about it. How many cases do you hear about like this? A few a year? How many cases are there? Millions. It's not like these cases are everyday cases. There are certain places like Louisiana, and I think to some extent Florida, where lawsuits bring big numbers. Sometimes, not always. And you need a lot of things to come together to make it work. So don't let it get below 285. 285 what? You confused me there. I don't know. I'm starting to get worried Tesla's trial counsel could have done more, a better job. Well, you can always, hindsight is 2020. You can always go back and, what do you call it? Armchair quarterback and say, oh, he should have done this. They should have done that. We don't know what they had in front of them. We don't know what decisions that they made. I don't fully know what happened at the court case. So I can't say that they made the right decisions or the wrong decisions. This is a more complex case. Shouldn't say this. Yeah, this is probably a more complex case than I've ever handled. It's a car accident case, which I've handled many car accident cases, and I've handled some pretty severe car accident cases. My biggest case, I won a $3.85 million verdict. Guy was sitting on a motorcycle, stopped in traffic, car coming the other way, hit a SUV coming the other way. The driver fell asleep at the wheel, hit him, drove another SUV, and he lost his foot at the scene, eventually lost his leg below the knee. And there was a lot of complexity to that case, and I did a really good job for my client. And everybody involved knew I did a really good job for my client. There's no question about it. I don't think it was as complex as this case, because when you get into product liability, which is, what is Tesla doing with its product? That's like another level of stuff that I never really dealt with. I think some of the stuff I did, accident reconstruction is very complicated. My case involved accident reconstruction. The other side's expert had this ridiculous story about how my client pulled out on his motorcycle to pass other cars, and that's how the collision happened. There's an eyewitness 2 vehicles behind who said he just was sitting there and this happened. Like a librarian, like the dream witness. Just sitting there. He was angry that the other guy crossed the center line. And the other driver's like, I don't know what happened. I think I fell asleep. But they have this expert, and along the way, I dissected. This is my expertise. My expertise as a lawyer, and understanding, because I'd done a lot of work with accident reconstructions as a car accident lawyer. At one point, he had this Harley, which has a 5 foot. If I remember correctly, the wheelbase on the Harley was 5 feet 8 inches. That the front and rear tires were making marks that were 7.5 feet apart. How do they do that? And I think he admitted he got paid $20,000 for like 2 days' work. And I didn't see it, but the judge said that juror really got mad when she heard that. He said that juror, she went. So I have some experience with some complexity in cases. Sorry for going off on lawyers love telling war stories. Warren is right. Bad jury decisions happen every day, especially in certain jurisdictions like where I live in Southeast Texas, Louisiana. New York City has some bad ones. South Florida does have some bad ones. Some other parts of Florida, maybe. And this is a thing, by the way, people think it's all the Democrats' fault. A lot of these Republican places, the judges, the lawyers are making tons of money, and they're all Republicans, and they're very good friends with the judges and the insurance company lawyers. It's like, if you didn't have these big verdicts, then insurance company lawyers wouldn't make much money either. Think about the system, the way the system works. And if you didn't have all these big verdicts, then insurance companies wouldn't have to charge such high premiums, and they wouldn't be able to make as much profit. And I want to be clear about this. I have advocated for years, many decades, we should change the system so that in order to get pain and suffering damages, you have to show something more than ordinary negligence. Ordinary negligence, I made a mistake. Gross negligence is you were driving 150 miles an hour in a school zone when the kids were present. Right? I'm not saying that's the line, but somewhere in between those two, you have the line between gross negligence and ordinary negligence. I was going 5 miles an hour limit, ordinary negligence. Now, maybe they would be able to prove that Tesla committed gross negligence here. They got punitive damages, but I don't see that making sense. But anyway, if you had that rule, you'd wipe out 90% of personal injury cases in the United States or wherever you did it. And anytime I said this to a plaintiff's lawyer, they just like, tell a criminal defense lawyer you want to legalize marijuana. I make too much money defending marijuana cases. I smoke marijuana, but I don't want it legal because I make too much money at it. Will investing in XAI tank the stock? We're not talking about that today. What scares me most is that the courts can go wrong. Yeah, the 3.5 million, by the way, Gavin, because the expert got paid so much, and because they fought issues they shouldn't have fought. They shouldn't have fought whose fault. They should have gone to the jury and said, you know what, he's really hurt. It was our fault. We think you should give him a lot of money. $500,000, a lot of money. They said that, they probably would have gotten that. I don't know what I would have done. That's because I've done that as a defense lawyer. He's really hurt. I think you should give him a lot of money. And the guy was asking for like, $500,000. The jury gave him $7,500 because they could see, oh, okay. Because they could tell we had made an offer. They didn't take the offer. They knew you're making us waste our time because you're looking for money. Do I think this case was influenced by the Nader Pinto case? No. Juries are deciding based on who it is rather than what they did. Probably if the defendant was McGee settled in a separate case. And they found, I don't think I mentioned this. The jury found 66% on McGee and 33% on Tesla. I just find this insane. He's got the accelerator pedal down, pushing faster than it's supposed to go. He's not looking for 11 seconds. He admits it's his fault, and somehow it's only 66%. Don't get to appellate issues yet. The judge has to make final rulings before it goes. There's post-trial motion issues, and then after the post-trial motions and the judge issues a judgment, then there may be appellate issues. Barack Obama nominated. I don't care who Obama nominated the judge. In Republican places, Republican judges do the same things. To what extent did you get in cases as a lawyer emotionally? Mostly not. There were probably 5% of my cases that I get really emotional. I may get excited, right? But emotionally involved? Not much. Once in a while. But I would say not much. I'm probably worse than some other lawyers, but you can't have no emotion, right? You have to believe in your case. I'm sure there are lawyers who are really good at faking the emotion. I don't think I'm good at faking it, but I don't think, if I lost a case, move on. I'm sure there's some cases that I was upset about and I felt bad about.
In the crash. The idea is that if the driver...
We're going back to some Fred. We're getting close to the end of my slides, if we can call them that. And then we're going to move on.
In the crash, the idea is that if the driver was in another car that didn't have autopilot, he probably would not have put himself in a situation that would lead to the crash.
How do you know that? This is a point we talked about earlier. How does Fred know that? How does anybody know that? How do the experts know that? He probably, maybe. How do you get probably? How do all these accidents happen with other cars? How come all these other accidents happen with other cars more than happen with Teslas, but people drive more recklessly or more carelessly because they're driving a Tesla? This doesn't make any sense. But he's Fred Flintstone. He hates Elon. I don't know.
Even though the driver is bearing the bulk of the responsibility, Tesla is being assigned a percentage of it, which could have big impact on other lawsuits, because this is just one of many unfortunate fatal accidents involving Tesla's autopilot and full self-driving.
So there's two things here. First of all, many. Fred has an exaggerated idea of how many cases actually involve autopilot. There are cases that the media have reported, fine media like friends don't let friends read electric media. There's many cases where media have reported that an accident was caused by autopilot or FSD that later turned out to be, or even quickly turned out to be, nothing to do with autopilot or FSD. Right? But the driver get out of the car, or, the car was driving. And then, of course, they look into it and nothing ever happens. So my best guess is there's like less than 20. He says over 50. My best guess is less than 20. And several of them, like Tesla settled the ones where it was at fault. And a lot of these are older cases. This case we're talking about is 2019 on autopilot. We're not even talking about FSD. There's a ton of these cases that not a ton. There's a bunch of cases that media reported blaming on FSD or autopilot that turned out not to be. Right? So his number is like every case anybody ever imagined might be caused by Tesla. And the real number is probably less than 20. Now, the second question is this precedential? Does this affect other cases? No. There's no precedent set by a jury verdict. There's the judge will make decisions. So there may be some precedent from the judge's summary judgment decisions, but not yet. It's really what he decides in the post-trial motions that could have some precedential value, but the precedent of a local district court is generally limited in any meaningful way to the local district court. Some extent, courts in the area, but usually courts in California don't look to Florida courts, local courts, to decide local district courts to decide what the law means. Now, the case is appealed, and there's a decision on appeal from the circuit court. It's the 11th Circuit Court of Appeals, the federal circuit court, one step below the Supreme Court. If the circuit court there makes a decision, that has more precedential value. It has strong precedential value for every court in the circuit, which is Florida, Georgia, and I don't know, 2 or 3 other states is my best guess. It's a big circuit. I don't remember how many. I know it's Florida and Georgia, and I forget what the other states are included. Maybe South Carolina, maybe Alabama or something like that. I don't know. It's probably more than that. So that's strong precedential value there, some precedential value elsewhere. But that's like the precedent is when judges are making decisions, they have to consider how did this judge make a decision. Now, there's a theory that, plaintiffs' lawyers will get excited and they'll bring lawsuits against Tesla because of this one. They're already doing it. There are already lawsuits being brought. This case was brought, right, when all the cases were against it. The idea that, okay, now we can sue Tesla. Like they weren't suing Tesla already? Let's look at the chat for a second. What sounds good for breakfast? I have a mix of yogurt. Well, so I start with berries and milk. Then I add chia seeds and yogurt and protein powder and creatine monohydrate. And I mix it up, and then I throw in some kind of cereal. Granola, typically. Usually a high-protein granola with some sugar in it, but not too much. And it's like less than 500 calories. It's got, I don't know, it's probably got 50 grams of protein or 40 or 50 grams of protein when you add it all up. So that's my typical breakfast. Eggs are also great for breakfast, but I don't have them with that. I did that what I said this morning, and I added a peanut butter and blueberry jelly sandwich. I don't know if you guys know I lost weight. I'm down to about 96 kilos. I was up to like 102, 103, maybe 4 months ago. 3-4 months ago. Fred and Thunderfart are having a baby. Thunderfart, not bad. When this BS award gets slashed and reversed, how do I know the hater media will ignore that nose? Yes, the media, this will get knocked down. The number's 243 or something like that. It's going to end up at like 40 million. And that, I'm making up numbers. It might end up being 5 million. Might end up being 10 million. We'll see. Can I do a video sometime reviewing all the other cases where media blame Tesla? I'm not making that many videos, and that one doesn't excite me. I'm doing a lot of live streams talking about what's happening at the moment. I think that video would be, I don't know, people would want to watch that. When this jury award gets back, wait for the anti-Tesla backlash. Yeah, if it's a big, I don't think the media will cover it. Mark, I don't think the media is going to cover that. Can't be precedent at all until after this final resolution of all issues. It could be like a tiny bit precedent that there's a summary judgment decision, but like the same court, like some other case that happens to be going at the same time. It's very, very minimal precedent. French fries are a good breakfast. Try Zen basil seeds instead of chia. Okay. Thank you, Gavin. If you let your head of hair grow, what would it look like? It would look like this. It would look like that. Do I agree Cummings has forevermore damaged her expert status from here forward? No, in academic circles, this probably makes her more. She's a professor at Duke University. She's probably, I think she was a professor at Duke University. Um, they're going to love her all the more if they don't care whether she tells the truth or not. We're talking about the media. We're talking about academia. Okay, a little bit more. I got to get to the saucy details. Believe it or not, there are saucy details to this case. Angulo is the guy who didn't die. Seeks to exclude testimony regarding the extent and specifics of his addiction to Xanax in high school, as well as later use of marijuana and crack cocaine. Tesla argues the evidence is relevant to his damages as indicated by the voluminous evidence that his drug abuse contributes to his alleged mental and psychological issues today. Oh, this guy's a winner. It's going to get, believe it or not, it's going to get worse than this. Believe it or not, it's going to get worse than this. The court agrees. This is where the court is ruling in favor of Tesla. The court agrees that to the extent that there is an adequate foundation to support the conclusion that his mental health issues may be attributable to his prior drug use, and such testimony is admissible. Although there may be other evidence at trial that court deems unduly prejudicial, court does not find the examples highlighted by Angulo sufficient justify limiting the extent of an expert's anticipated testimony on the issue, let alone the wholesale exclusion of such testimony. Accordingly, so here, this is shortly before trial. The judge is ruling in Tesla's favor, and here again, I'm not going to get into what happened here, but Angulo argues that Crown's opinion. So Tesla has a medical expert that is going to argue that this guy's mental problems are not caused by the accident; they're really caused by his other problems. Crown's opinion that his pre-morbid drug use, ADHD, and depression were contributing factors of his current neurocognitive disorders of brain damage is not based on sufficient facts or data. So there's another ruling. But this guy had a mess of problems before Tesla. He had an encounter with Tesla. But here's the gold. Here's the gold. Are you ready? They want to preclude testimony of his bad character or prior bad acts. So the general rule is you can't use prior bad acts like criminal convictions unless there's a reason to use them. So he wants to exclude any testimony regarding his prior bad acts, including his sex and love addiction. You'll see why that matters in a minute. His departure from rehab against medical and clinical advice, and his prior drug withdrawal. He doesn't want that in. The court will not exclude this evidence as improper character evidence, as Tesla has provided a legitimate non-propensity reason for introducing such evidence. Okay. If you tell the jury he's a bad guy and you show the jury his bad character, the jury might rule negatively against him. Now, we don't know what happened at trial, but this is before trial, whether this was going to come in. As Tesla explains in his response, evidence regarding Angelo's love and sex addiction, this is where it gets better, and the relationships he had with other women before, after, and possibly at the time of the subject incident. Remember, this is being sold as he was her boyfriend. We don't know how many other girls he was boyfriend with at the same time. In other words, he's been banging other women before, he's banging other women after, like shortly after, and maybe even at the same time of the incident, he's banging other women, but this is his girlfriend. Is relevant to undermine the credulity or the credibility of Angelo's claim that he's suffering from PTSD due to the loss of someone he had only known for a few weeks. Okay, so we don't even know if this is his side chick or his main chick. But I lost my girlfriend of 3 weeks while I was fucking other women. I'm sorry. No, I don't think they were having sex at the time of the accident with another woman. No, they were standing on the side of the road. But in the same general time frame of the incident, as in maybe that day or the day before, the day whatever, in a few days before, he's been dating this girl for 3 weeks. Apparently, he's having sex with other women while he's dating this woman. His failed drug addiction recovery before the subject collision is relevant because of the tendency to establish an alternative explanation for the cause of his anxiety, depression, sleep issues, and anger issues. Admitted to his care providers that his depression was related to his substance abuse. So that was the juicy sex addiction stuff I had to bring up. Sounds like my ex. Oh, B, that's an interesting thing to tell us. Thank you, B. Lots of women have bad exes, don't they? So now I don't know what actually happened at trial. We don't have that information yet. We're going to have post-trial motions. My guess is that the verdict will be reduced. So I believe the total against, a really good example is the judge could say, 66-33 is probably not right. I'm going to make it 80-20. That's an example of what the judge could do. Or the judge could say, I've looked over the evidence that actually went in at trial. And now I've had a chance, because at trial, at the trial, it's hard for the judge to make decisions because he's got to make decisions on the fly. But I've looked back on this and, I'm going to take away this theory that I gave the plaintiff before on summary judgment and eliminate before trial. So I'm going to take this one away. And as a result, I'm reducing Tesla's liability from 33% to 20% or 33% to 15%. I'm just saying, I'm not saying he will do it. I'm saying conceivably he could do that, right? Conceivably, he could say, okay, the total award for compensatory damages was $120 million between the two of them. I think that's the number. 129 million, something like that. But I think this number's wrong, this number's wrong. He ends up reducing the woman's award from, I'm making up numbers. And it's 129 million. Tesla's only on for a third of that. Now, if you knock it down to 20%, Tesla's on. Again, I'm only saying what could happen. Now Tesla's down to 25 million for that. So maybe he knocks down the total award for everybody from, let's say, 129 million to 60 million. Still a lot of money. I'm not saying he will. I think those numbers are not crazy under Florida cases in the past. I think the guy's award seems a little insanely high. Like the girl's award probably is going to hold up pretty much. I think the guys of this Angulo guy, I could see the judge knocking that one down. Now you get to punitive damages. My gut hunch is that, and I assume, I don't know how they apportion who gets what share of the 200 million. I think the judge has to knock it down. Let's say it's Tesla's share of the liability is, let's say he knocks it down to 25 million. Florida's cap is 3x. But I don't know this from my own experience of Florida law. Other people have been saying there's a cap of 3x. Well, that would mean you couldn't go more than 75 million on punitive damages. You're at 100 million instead of 240 million. 243, whatever. I think that the judge has to go to 1-to-1. I think, based on what we talked about before here, I think this one, the court reduced to a 1-to-1 ratio because you need predictability and fairness, and you need cases of extreme reprehensibility with low compensatory damages. I think we could go down to 1-to-1. If you go down to 1-to-1, and let's say the total damages is reduced to, 30 Tesla shares down to 30 million. Now you got 30 million, you got 60 million. So you can see where it goes from 240 million down to 60 million pretty quickly. And then you get appeals. And all right, we're at 60 million, and Tesla and the other guy's lawyer are talking, and Tesla lawyers, and all of a sudden they settle on 50 million, and that number's not disclosed. Look, if we go through all these appeals, you might lose everything. Let's settle on this number. And they might agree to that number. So next big future. Hey, Brian, he says, in the appeal of the $329 million verdict, can Tesla revisit the ridiculous 11-second fault of Tesla? First of all, before appeal, we're going to post trial motions. Tesla says, this is judge, these are the things that I think you got wrong. Not what the jury got wrong. Judge, these are the things you got wrong in the case. We'd like you to revisit these decisions you made, change your decisions. The judge looks at it, and you'd think the judge would be offended by that. Like, no, that's part of the game. That's what judges do. So the judge looks at it and says, okay, I've looked at what you've said, and I'm going to change my decision on this or change my decision on that. And then, this happened during the case, and judge, we want you to rule. And the judge makes some rulings. At the end, the judge says, here's my final ruling. Now there's an order. Tesla has to pay this much. It's not that they have to pay it tomorrow. This is like the final ruling. This is the judgment. Tesla, this is how much you owe them. Then Tesla files an appeal. Now you're talking probably at least another year. Bunch of stuff's argued. Decisions the judge made before trial. Decisions the judge made after trial. The Circuit Court of Appeals makes some decisions. We see where we are. Maybe the case settles. My guess is something like 75% of cases settle when they're on appeal. Some cases settle before the post-trial motions are decided. But, you end up on appeal. I think Tesla doesn't like this one and they want to appeal it and they want to get a decision. But, it could be on appeal. They find a way to settle it on appeal. And Tesla says we're going to appeal, and then, push comes to shove, it's going to cost us this much money to do this appeal, and, we can get this thing done and over with and knock it out and move on, right? If the circuit court makes its ruling and Tesla's still not happy, they can go to the Supreme Court. So we're going to see. Okay. Rock says you brush your nose with your hand because of the intensity of the topics you talk about. I like it. I like it. I like it. If you look around, that happens a lot in America and around the world. Money does not fix anything when you lose a friend. I think the big issue here is the woman who died, her family lost their daughter. I think she was like 22. Very tragic. And I'm not trying to make light of either one of them's injuries or, her death. I think the issue is, why is this Tesla's fault when you had a guy pushing his foot down the accelerator pedal, which you're not generally supposed to do first of all, you're supposed to pay attention. Second of all, you're pushing your foot on the accelerator pedal. You're telling the car, I'm paying attention. If you're pushing, this is one of the things. If you're pushing your foot down on the pedal, you are telling the car, I'm paying attention. I believe he's also holding the wheel. He's got his foot on the pedal. He's holding the wheel. Hi, Brian. LJ says, I would think the substantive issues here aggravate in favor of complete reversal. We don't know enough to say what will happen. I can say, I see some things like this doesn't look right. But, I'm not putting the level of analysis in that an appellate lawyer or an appellate judge would put in. I got, 5 hours into this. 10 hours? The lawyers have hundreds of hours, maybe 1,000 hours in this. And the appeals lawyers are going to have hundreds of hours in this. So there's a lot of people who are going to go a lot deeper than any of us could go on a live stream or anything. LJ says, Warren, solely talking about Cummings' alleged professional opinion in the case, not her non-legal followers. One would think that opinion can successfully be used against in future testimony. I don't think in general you can use... I guess I'm not sure what you mean. I think that as a trial lawyer, if I have a transcript from another case where an expert admitted something, we use that against those experts every chance. Like, there are some regular experts that appear in our court cases, and when I was in upstate New York doing personal injury trials, and there'd be some doctor who's a regular witness for plaintiffs' lawyers, and then it turns out he gave I can't remember the guy's name. He did a seminar. It didn't say this, but it was something like how you can make money as an expert witness. Like, because most doctors, when they testify, they're like just doctors who treated an injured person, and somebody, my experience, most doctors who testify are like, they're doctors who treat patients, and then if somebody asks them to testify, they charge a fee because they're taking time away from their work, and we used to pay them like $3,000 or $5,000 back in this is many years ago. I paid one doctor $7,500, but he was like the best orthopedic surgeon in the world. So we would pay doctors some money to show up. But there's doctors who figure, hey, I can make more money as a witness than I can make as a doctor. And let me do a seminar and tell all these other doctors how they can make money as an expert witness instead of working as a doctor. Juries don't like that. They don't like those experts. So if you catch them doing something like that, it's used against them to the end of time. So if you're a doctor who likes testifying as an expert, don't tell anyone that. The future of tech at people's expense, courtroom lawyers. Yeah, pretty much. You can always impeach an alleged expert in future cases when they said something. It depends. Not when they said something stupid previously. It has to be useful, and a judge can say, no, you can't ask about that. The lawyer that the expert's working with says, no, you can't. Judge, don't let him ask that question. You don't get to ask it. Okay, so I think I've explained why kettlebells matter and why you should follow Kettlebell Dan on X. And I think I've explained that this Optimus is not an actual physical Optimus. It's an image. And I do not have an Optimus toy. Don't ask me where I bought it. It's an image I found online or altered after I found it online. Yeah, and as Mark said, please like, share, and subscribe. It is after my bedtime, so I'm going to go to sleep and rest with my wonderful wife. Yeah. Anyway, thank you, LJ. Thank you to Mark for moderating the chat. Thanks to the regulars. Thank you, Brian, for showing up. And I'm gonna go to sleep, and I'll probably have another video in 2 or 3 days. I'm loving doing these live streams, so we'll do more. Thanks, everybody.